Mike Brown, the former FEMA director.
Joining us here is the former FEMA director.
History, I think, was very unkind to you, my friend. Very unkind.
Mr. Brown, thanks for being with us.
This is Michael Brown Unplugged.
Hey, everybody. Welcome to this episode of Michael Brown Unplugged. I know that we've talked an awful lot about impeachment, but something happened on Tuesday, October 8th, that I think is worth spending a little bit of time talking about. And what happened on that date is that a lawyer for the president, a Pat Cipollone, I'm not quite sure, Cipollone, Pat Cipollone, a lawyer for the president, sent a letter to Pelosi, to the chairman of the House Foreign Affairs Committee, Congressman Engel, to the chairman of the House Permanent Select Committee on Intelligence, Adam Schiff, and to Elijah Cummings, who is the chairman of the House Oversight and Reform Committee. And the letter is essentially outlining why the president is not going to cooperate with the impeachment inquiry. And I think this is an astonishingly well-written letter, very well footnoted, and puts together in both a historical context and in a modern context and in a procedural context why this impeachment inquiry is such a complete farce. Impeachment is governed by the Constitution. So let's first lay out, what does the Constitution say? The Constitution provides that the House of Representatives, quote, shall have the sole power of impeachment, Article 1, Section 2, and that the Senate shall have the sole power to try all impeachments, but no person shall be convicted without the concurrence of 2/3 of the members present, Article 1, Section 3. The President, the Vice President, and all civil officers of the United States are subject to impeachment. Now, the whole concept of impeachment originated in England and was adopted by a lot of the colonial governments and state constitutions. In Federalist number 65, Alexander Hamilton said that impeachment is a method of national inquest into the conduct of public men accused of violating the public trust. Hamilton and his colleagues at the Constitutional Convention knew that the history of impeachment as a constitutional process dated from England back in the 14th century, when the very beginnings of Parliament tried to make the king's advisors accountable. And then by the mid-15th century, impeachment had fallen into disuse, but then in the 17th century, because of the excesses of the English kings, Parliament then decided to revive its impeachment powers. So even as the Constitution's framers were working on the Constitution in Philadelphia back in 1787, the impeachment trial of a British official named Warren Hastings was in progress in London, and it was being avidly followed here in America. Hastings, who was eventually acquitted, was charged with oppression, bribery, and fraud as a colonial administrator and the first governor general in India. The bottom line is, impeachment is a political process. It has the trappings of a trial in the sense that you have to have due process, you have to be able to confront your witnesses, you have almost like a grand jury. The House of Representatives is like a grand jury. And if the grand jury decides to impeach a president, or for that matter, a federal judge or anybody else, and that passes the House of Representatives, it then goes to the United States Senate, where the Senate acts as a jury. And then you have to have 2/3 of those present voting to convict. Now, since 1789 in the adoption of the Constitution, one principal question has persisted, and that is, how do you define the phrase high crimes and misdemeanors? This has been debated by Congress, lawyers, legal scholars. It has been debated all the time. Were misdemeanors lesser crimes or just misconduct? Did a high crime or a misdemeanor have to be a violation of some written law? In an unsuccessful attempt to impeach Supreme Court Justice William O. Douglas back in 1970, Congressman Gerald Ford, remember him? Later President Ford, said this: an impeachable offense is whatever a majority of the House of Representatives considers it to be at a given moment in history. Now, that's still subject to debate, and it pits those who view impeachment as a response to an official's perceived violation of the public trust against those who see impeachment as being limited to indictable or what you and I would consider to be criminal offenses. So the bitter animosities growing out of the Civil War gave rise to the first impeachment trial of the United States President, Andrew Johnson, in 1868. And since then, there have been various impeachments of federal judges, different cabinet officials. The most recent one, at least in modern history, is during the summer of 1974, in wake of the Watergate scandal. The Senate was preparing for the possibility of a second presidential impeachment trial, and the House of Representatives was moving very close to impeaching President Richard Nixon. In July of 1974, the Senate adopted a resolution directing the Senate Committee on Rules and Administration to review the existing impeachment rules and precedents and to recommend revisions. The committee, aided by Senate parliamentarian Floyd Riddick, devoted long hours to the Senate's constitutional role in impeachment proceedings. The committee was meeting on August 8, 1974, when Nixon, after having received an entourage of Republican members of the Senate and House telling him that they were moving forward with impeachment, that he announced that he would resign. But here's what's interesting, and most people don't realize this. Despite that unprecedented event, the president announcing his resignation in light of a potential impeachment, this Senate panel continued to work under a mandate from the Senate to file a report by September 1. That report was filed and contained recommendations that were primarily technical changes in the rules that had been adopted in 1868 for that impeachment of Andrew Johnson. But with the resignation of Nixon, no further action was taken. But all of those recommendations still exist. And all of those recommendations still form the basis of how, at least in my opinion, I think impeachment ought to proceed. And here's where the big rub is. Nancy Pelosi, when she came out prior to the release of the transcript of the president's conversation with the president of Ukraine, and announced that they were starting a formal impeachment inquiry, she did so without the vote of the members of Congress. And here's why that's so important. Impeachment as a political process should demand that every member of Congress, every member of the House of Representatives, needs to go on record as to whether or not they want to start an investigation regarding impeachment. And the reason that's important is this. That forces both members of both parties, to take a stance on whether or not they want to conduct an investigation. There's virtually no investigation that isn't started without some sort of formal vote. And in particular, if you're starting an impeachment proceeding, an impeachment investigation, you're putting the House on notice that we want to investigate. And let's just take Trump out of the picture. Let's say, for example, that there's a federal district judge. Alcee Hastings is the one that comes to my mind, a former federal judge in Florida. He was impeached, I think, back in 1989. Don't hold me to the date, but I think it was in 1989 that they were considering evidence. In order to start that impeachment proceeding against a federal judge, there was a vote on a formal inquiry. Now, if you're going to have a formal inquiry based on a vote for a federal judge, doesn't it make even more logical sense to have a vote of the entire House of Representatives about whether or not to start an investigation of a president? I think they do. So let's go back to the letter dated October 8. Dear Madam Speaker and Messrs. Chairman, I write on behalf of President Donald Trump in response to your numerous legally unsupported demands made as part of what you have labeled, contrary to the Constitution of the United States and all past precedent, as a, quote, impeachment inquiry. As you know, the lawyer writes, you have designed and implemented your inquiry in a manner that violates fundamental fairness and constitutionally mandated due process. And just the second paragraph, it's an 8-page letter. I'm not going to read the entire 8 pages, but I want to give you the highlights to point out why I think this is nothing more than a relitigation of the 2016 presidential election. There is no basis, at least at this stage, to impeach the president. But parenthetically, I would note, I hope the hell they do. Back to the letter. For example, the lawyer writes, you have denied the president the right to cross-examine witnesses. What does that mean? Well, they're calling all of these witnesses to testify before these different committees, and they're not allowing anybody from the White House or anybody from the president's legal team to be present at the questioning of these witnesses. It's like a star chamber. It's like a secret court somewhere. If you're going to have an impeachment inquiry and you're going to start dragging witnesses to testify, then the president should be able to what? Have his day in court, to have his right to cross-examine those witnesses, or at the least to be able to hear what the witnesses are saying. Back to the paragraph. For example, you've denied the president the right to cross-examine witnesses, to call witnesses, to receive transcripts of testimony, to have access to evidence, to even have counsel present, and many other basic rights guaranteed to all Americans. You have conducted your proceedings in secret. You have violated civil liberties and the separation of powers by threatening executive branch officials, claiming that you will seek to punish those who exercise fundamental constitutional rights and prerogatives. All of this, he writes, violates the Constitution, the rule of law, and, in quote, in boldface, in italics, all of this violates the Constitution, the rule of law, and every past precedent. Never before in our history has the House of Representatives, under the control of either political party, taken the American people down the dangerous path you seem determined to pursue. Put simply, you seek to overturn the results of the 2016 election and deprive the American people of the president they have freely chosen. You know, he's exactly right. And then he goes through several points that I just want to highlight. Number one, your inquiry is constitutionally invalid and violates basic due process rights and the separation of powers. In the history of our nation, he says, the House of Representatives has never attempted to launch an impeachment inquiry against the president without a majority of the House taking political accountability for that decision by voting to authorize such a dramatic constitutional step. And to that I say amen. Because remember, this is a political process. It's a political process that is infused with certain rights and responsibilities, that is infused with the basic tenets of due process, that is infused with the basic rules that govern the conduct of the House of Representatives. I'm not even talking about the Senate yet. I'm simply talking about the House of Representatives. There are certain rules and procedures that they need to follow, and they are not doing it. Think about this. Why would it be that Nancy Pelosi would come out, hold a presser, and say, I am starting a formal impeachment inquiry, but I'm not going to require my members, my Democrat caucus, to vote on it? Because you would make an assumption, wouldn't you, that all Democrats would vote to have an impeachment inquiry, to start the formal process. And indeed, I think they would. The problem is political. The problem is Democrat members from moderate districts, swing districts, red districts, districts that they barely won, they may not want to go on record as having voted to start a formal impeachment inquiry. I don't think there's a guarantee that Nancy Pelosi could get the necessary votes. I think she would, but there's no guarantee. Here's the other reason. I want Nancy Pelosi to follow rules and procedures, and I want her to hold a vote because you know what I would like to see? I'd like to see every Republican member of the House of Representatives vote in favor of an impeachment inquiry. You know why? Because now you've made it bipartisan. Now Republicans have said, you want to impeach this president? Let's get it on. And now we're going to force you to play by the rules. You want to call the former ambassador? You want to call some envoy? You want to call some member of the administration? Unless they invoke executive privilege, we're going to make certain that that witness testifies openly in front of the American people, and that we get to cross-examine, and that the president's lawyers get to cross-examine. By damn, if we're going to have an impeachment inquiry, let's have an impeachment inquiry. They're playing games, and I'm sick of it. And here's why they're playing the game. They're playing the game because by doing so, it allows the fourth branch of government. Michael, there's only three. No, there's a fourth branch of government. And it is solely in the control of the Democrats. And that's the media. And right now, the media is doing everything they can to drive public opinion to think that, oh my gosh, there must be something wrong. I mean, all I hear about every single day is impeachment, impeachment, impeachment. So Donald Trump, that Donald Trump, well, he tweets out crazy things sometimes. And that Donald Trump says some bad things sometimes. And that Donald Trump, well, I kind of voted for Donald Trump because I want him to upset the apple cart in Washington, D.C. But, now I'm beginning to think that maybe he took the apple cart and he was drunk when he drove it and upset the apple cart. They're trying to drive public opinion. They're trying to have it both ways. And to that I say, screw you. Number two, the invalid impeachment inquiry plainly seeks to reverse the election of 2016 and to influence the election of 2020. Democrats themselves, he writes, used to recognize the dire implications of impeachment for the nation. For example, in the past, Chairman Jerry Nadler of the House Judiciary Committee said this: the effect of impeachment is to overturn the popular will of the voters. We must not overturn an election and remove a president from office except to defend our system of government or our constitutional liberties against a dire threat. Let's just pause for just a moment. Has Donald Trump threatened our constitutional liberties? I pause because I'm honestly thinking, what has Donald Trump done? I mean, he did make that statement one time about extreme risk protection orders, and perhaps maybe not everybody needs an AR-15. That was not really a threat, but it certainly indicated to me his state of mind, a state of mind that I didn't like. But back to Jerry Nadler. There must never be a narrowly voted impeachment or an impeachment supported by one of our major political parties and opposed by another. Such an impeachment will produce divisiveness and bitterness in our politics for years to come, and will call into question, he says, the very legitimacy of our political institutions. Quite honestly, I think that's what the Democrats want. I think they want the American people to lose trust. They want this discombobulation among the American public. Because when the public is confused, frustrated, sick, that gives the Democrats the opportunity to ride in on the proverbial white horse and save America. And that's what they're setting this up as an attempt to save America from the tyranny of Donald Trump. If you don't like the tyranny of Donald Trump, which I think is an oxymoron to begin with, but if you don't like the tyranny of Donald Trump, there is a solution to that. And in fact, we're right in the middle of that solution. The Democrats are trying to choose who's going to be their opponent to try to unseat Donald Trump. There are even a bunch of dumbass Republicans like Bill Weld and a couple of others who want to run against Donald Trump. That's how, if you don't like what Donald Trump does, and absent Donald Trump doing anything that is a violation of the Constitution, that is an impeachable offense, the way to get rid of him is to vote him out of office. That's our political process. And then one last thing about the letter, which I think is incredibly important because you're going to hear a lot about this. The lawyer writes, given that your inquiry lacks any legitimate constitutional foundation, any pretense of fairness, or even the most elementary due process protections, the executive branch cannot be expected to participate in it. Because participating in this inquiry under the current unconstitutional posture would inflict lasting institutional harm on the executive branch and lasting damage to the separation of powers, you have left the president no choice. Consistent with the duties of the President of the United States, and in particular his obligation to preserve the rights of future occupants of his office, President Trump cannot permit his administration to participate in this partisan inquiry under these circumstances. In other words, the president's going to invoke executive privilege, and he's going to instruct people who get subpoenaed by Congress not to comply with the subpoenas. I don't want to go into a lot of detail except to say this. Those people will not be subjected to any criminal prosecution. That is a classic clash of separation of powers. The executive branch is entitled to exercise executive privilege. If Congress wants to subpoena somebody, they're going to have to go to court, and they're going to have to use the third branch of government in this three but separate equal branches of government and separation of powers to determine whether or not the president is lawfully invoking executive privilege. And under these circumstances, I think that he is. Now, if the rules of the impeachment inquiry were different, if they were saying we want to subpoena, the ambassador to Ukraine, we want to subpoena the chief of staff, we want to subpoena all of these executive branch members. But, Mr. President, you're more than welcome to have your lawyers present, to witness the examination, to participate in cross-examination, to read the transcripts, to participate in the process. When you're not allowed to participate in the process, when you're not afforded the fundamental rights of due process in this impeachment farce that's taking place right now, I think the president is well within his rights to exercise executive privilege and to instruct people not to participate. If the impeachment inquiry had been formally voted on, and if the witnesses were allowed to bring their own lawyers, and if the executive branch, i.e. the White House, i.e. the president, were able to participate in the examination and cross-examination of witnesses, to be able to have the transcripts, to be able to be present when people are questioned and not have these secret hearings, then I think the court might rule, no, you have to let them participate because they are following the rules of due process. There's my take on this impeachment inquiry. If you have the opportunity, you need to Google or DuckDuckGo or Bing or wherever you do your search, and you need to search for White House letter dated October 8, 2019, signed by Pat, initial A, Cipollone, Cipollone. It's online. You can probably find it anywhere. It is worth your time to read it. Thanks for listening to this episode of Michael Brown Unplugged. I hope I've given you a little information, a little additional information, a little historical context about impeachment. I'm sick of the story, but as long as we keep having this kind of misinformation floating around about impeachment and about this particular inquiry, I'm going to continue to get on my soapbox, and I'm going to continue to talk to you about the history of impeachment, the process of impeachment. Why do we have impeachment? What are the rules and regulations that govern it? What's the historical precedent for doing something the way the Democrats are doing it now, which is virtually non-existent? And what would be the proper precedent? If you really want to impeach Donald Trump, do it the right way. Stand up, play your cards, and let the American people understand exactly what you're doing. You're hiding because you know that if you just do the impeachment inquiry and you start leaking and you start setting up these false battles between executive privilege and people being subpoenaed and everything else, you know that you're going to get the spin from the media that's going to eventually convince the American public that you're right and that everybody else is wrong. Well, in my little world, I'm going to fight that every step of the way. I'll talk to you tomorrow.